Hello, everyone, and good evening. My name is Josh Hacker, and I'm the Executive Director of the Anthony V. Cardona Moot Court Program here at Albany Law School. And it is my pleasure to welcome you all to the final competition round of the Donna Jo Morse Negotiations Competition. This final stands as a testament to the hard work, dedication, and advocacy skills of the students here at our school. First, I want to recognize our competitors. Thank you to all of them for allowing us to be part of this chapter of your legal career. Your journey throughout this competition has been filled with challenges, learning moments, but your participation in this competition has already truly set you aside from your colleagues and as future leaders in this profession. I want to take a moment also to express my thankfulness to those who have made this competition possible, starting with the competition chair, Margarita Krenova, a stunning example of someone who stepped up to the plate when we needed her the most. She has went above and beyond in fulfilling her spring chair duties, even though they may have not been a part of her plan initially when we hired her as Associate Director of Finance. Margarita has created several competition problems this spring that were both interesting and challenging. I can personally attest to both since I had the privilege of competing as a ghost team for a round in this competition, and the level of detail required to fully appreciate the facts of these competition problems was very impressive. Of course, these problems were fine-tuned to near perfection with the help of the competition's faculty advisor, Professor Bollana, and these problems have helped our competitors grow in their negotiation skills, and I'm incredibly grateful to Margarita and Professor Bollana for their hard work. I would also like to extend my appreciation to our competition associate, Hallie Dennison, for her support, attention to detail, and dedication to this competition and the program as a whole. It takes a tremendous amount of coordination to bring this competition to life, and her hard work and time sending emails, making schedules, coordinating with judges has not gone unnoticed, and I thank her very much for it. Thank you to our judges, those here tonight and who have judged earlier rounds, faculty, advisors, and those who have supported this competition. Your time and expertise has made this competition an unparalleled learning experience for our competitors. Thank you to you all as well. With that, I wish our finalists the best of luck, and we look forward to an exciting, skillful display of negotiation. And it is now my pleasure to introduce this competition's faculty advisor, Professor Bollana, to give a few remarks.
And thanks to Josh for leading this moot court board this year. He's done an exceptional job. I will be brief. Again, I'm here to welcome you. My name is Professor Dan Bollana, and as you heard from Josh, I am the competition chair. The moot court program here at the law school is really a cornerstone of our program here. And it's led by one of my most impressive colleagues, Professor Kanika Johar, and under her direction, students are able to build the confidence that they need to be successful advocates and also work on developing skills such as collaboration and clear, persuasive communication. These skills will serve them throughout their careers, and I know as I was a competitor here at this law school over 10 years ago, that it really helped me find a belief in myself that I could succeed as an advocate in the legal profession. And this experience is made all the more meaningful by the engagement of the members of the bench and bar of the Capital Region, whose time and thoughtful feedback are integral to our students' growth. And I am so grateful for the judges who have contributed their time throughout this competition and our distinguished panel this evening. Again, I have to extend my sincere appreciation to our competition chair, Margarita Krenova, and Hallie Dennison, the competition associate. Organizing competition of this scale is no easy feat, right? It takes a lot of time, dedication, professionalism, and leadership, and you displayed it throughout. So thank you both for your outstanding work. I'm going to turn it over to Margarita, who will introduce this competition. Thank you.
Good evening. My name is Margarita Krenova, and I am this semester's Donna Jo Morse Negotiations Chair. I, along with the competition associate, Hallie Dennison, would like to welcome you to this evening's final round. This competition bears the name of Donna Jo Morse as a dedication to the legacy and memory of the late Donna Jo, a 1991 graduate of Albany Law School. Upon graduation, Miss Morse remained at the law school to teach Introduction to Lawyering to first-year students. During her tenure, she, with Professor Patricia Rayhan, co-directed the Sawyer Workshops, an academic program created to enhance student success in law school. In 1996, she was awarded the Kate Stoneman Award for her tenacity, dedication, and devotion to her students, and for promoting excellence in legal education. Ms. Morse also served as the faculty advisor for the law school's ABA negotiation team from 1991 to 1995. During that time, she successfully guided the negotiation team to 5 regional championships. Due to cancer, Ms. Morse passed away in September of 1996 at the age of 39. This competition is held in her honor as a teacher, a mentor, and a friend. While they couldn't be here with us today, I would like to extend our gratitude to Mr. John Morse, Donna Jo's husband, to Patty Wenzel, Donna Jo's sister, and to Lawrence Yance, Donna Jo's father, who recently passed away late last year. This year, the competition was filled with incredibly talented individuals. Some rounds were neck to neck, coming down to just a few points. Everyone did a remarkable job. Tonight, you will see 2 final teams negotiating a merger agreement. 2 entertainment conglomerates, Filmflix and Miller Sisters Pioneering, come together to decide if they will come to an agreement. This all happens while Cardinal Global waits on the sidelines for their negotiation talks to fail. The general background to this problem can be found in the competition program for tonight. At the start of the round, the teams will enter one at a time to complete a pre-negotiation meeting for about 5 minutes in the presence of the judges. Then the teams will meet to negotiate the problem for 45 minutes, during which each team may take a 5-minute break if they need to. At the conclusion of the negotiation, the teams will return one at a time to complete a post-negotiation assessment. Upon completion, the judges will go into the judges' room to deliberate and declare a winner. The competitors must abide by the designated time limits. However, the judges in their discretion may allow for additional time. To judge our event this evening, please welcome Judge Jasmine Norman, Attorney Raymond Weiss Jr., and Professor Robert Heverly. All rise for the judges. Please be seated. Each of our judges' bios can be found in tonight's program. Our final teams this evening are Kathryn Benedetti and Timothy Nolan, representing Filmflix, MacKenzie Brown and Victor Gelfuso, representing Miller Sisters Pioneering. I would also like to introduce Kathryn Miechkowski, who will be serving as our official timekeeper. Without further ado, I would like to hand things over to the judges and let the competition begin.
Good evening. So I'm Kathryn Benedetti, and this is my partner, Timothy Nolan. We are representing Filmflix in this negotiation. So we see there being 4 main subject areas here: price, brand integration, the reverse termination fee, and exclusivity. Tim is going to take the lead on brand integration and the reverse termination fee, and I'll take the lead on price and exclusivity, although we did help each other prepare for all 4 subject areas and are willing to hop in when needed. We have the benefit of our public offer being known. So our strategy begins with starting the negotiation by asking the representatives of MSP what their thoughts are on that public offer. The aim is to learn what their main concerns are and then tailor our negotiation from there. We want to stick as close to the public offer as possible. We do predict that some of MSP's main concerns will be the liquid assets that they get from the deal, along with regulatory concerns. We are prepared to address both. As far as liquidity goes, we do have flexibility as to how much we make the offer as a whole. And we do want to emphasize the fact that our stock is valuable and the fact that MSP's stock rose 11% as soon as our offer was made public is favorable for us. As far as addressing regulatory concerns, we did do some research on cases that show precedent of similar deals that did go through. We want to start with that because we did not make any sort of a public offer for a regulatory termination fee. We want them to be the ones that push for that. So we'll start by showing the precedent. If there is pushback, we did pull a report from 2025 by Houlihan Lokey, which is an investment company that is well known for advising in mergers and acquisitions. And they show that a typical termination fee is 2 to 3%. So we'll start with that, but do have flexibility to go all the way up to a little bit over to 6%, which is a very aggressive fee. We did prepare a breakdown on what our offers would be based on the overall price, the corresponding ownership percentage, and what a reverse termination fee would be at 2 to 6% of that overall offer amount. This way, Tim and I will be on the same page and can adjust our figures with ease, and the math is all done in advance.
As my colleague has mentioned, we have a number of very, very good strengths on our side of the case. The biggest being our flexibility. Film Flicks, we're fortunate enough to represent them, a company whose back is not up against the wall. They're successful as they are, and they don't need this transaction to go through to continue being successful. And so we can handle this negotiation with that in mind, knowing that we could grow, knowing that our subscriber base could expand. However, it wouldn't be the end all be all if we didn't have a deal here today. If they went over our non-negotiable limits, we've been authorized to leave the conversation if the terms aren't agreeable to our client. Another massive strength is the strong brand recognition and the fact that FilmFlix is the most popular streaming service currently. And FilmFlix also wants to make clear that they have those red lines. If the other clients' representatives are insistent on going over them, we have, as I said, been authorized to leave the conversation if those terms aren't favorable to our client. And with the biggest weaknesses, the regulatory concerns, us offering a lower cash amount than our competitor, we do have ways to work around those with our stock inclusion. And we would also plan to emphasize that MSP stock went up 11% after hearing that we had made an offer. FilmFlix, being the most subscribed on-demand service, is willing to walk away and are prepared to address any of the other topics that were discussed. We're hoping to solidify the price first so that we can not only base the remaining negotiation topics from there, but if they then give pushback on brand integration, we can potentially offer more money as a bargaining tool. Exclusivity is going to be a very similar tactic. So, like we've previously mentioned, the ideal is to walk away as close to the public offer as possible, but we are able to go higher if it so demands. We will do our best to get the most optimal agreement for our client. Thank you.
Thank you.
So like we talked about, essentially at this point, we have two fairly competitive offers on the table, and this is FilmFlix's last chance to make the best sales pitch to us before we take their proposal back to our board of directors.
Exactly. Just in acknowledging that strong position we're in, we want them to take a lot of the lead on the agenda and bring forth numbers because we don't have to put anything forward. Our client is confident in their position. They enjoy the offers that are put on the table right now. However, it's their opportunity to sweeten the deal for us.
Right. And like the only specific thing our client has instructed us to get out of this meeting is that we need a reverse termination fee established to even consider going forward with their current proposal, because this is an inherently risky transaction. We're the two largest streaming companies in the industry. So there's a lot of antitrust concerns over a potential merger with direct rivals.
Absolutely. Additionally, we would prefer for exclusivity to be established last, just so we know what the final offer is on the table before we decide that we aren't going to talk to any other offerors like Cardinal.
And that goes right to our fiduciary duties, because we represent the board of directors who have a duty to get the best possible deal for the shareholders. That doesn't always mean getting the most money, because we have to take into account all of the other considerations, but we don't want to foreclose any other opportunities when we're not even sure that FilmFlix has given us their best possible deal.
Exactly. And especially because Cardinal has indicated to us that there is a potential that they're going to increase their offer, we don't want to shut that door just yet. Aside from those two things, we also anticipate there being a couple of other things we're going to discuss, and that's the overall price / the cash versus stock ratio. Next, potentially FilmFlix acquiring the cable company in addition to the streaming company. And finally, just brand integration as a whole.
Right. And those go to our clients' general goals. So like we said, they want us to get the reverse termination fee. But when it comes to other things, they've given us some general ideas about what they're looking for, but we do have a lot of flexibility. So when it comes to the cash stock breakdown, they do want to have more cash in general, ideally an 85% cash and 15% stock breakdown. But we're willing to consider anything above 60% cash.
Absolutely. And they don't want Streamco to be terminated immediately. They would like a 30-month brand integration period. However, we ideally would like to stay above the 12 months that was already offered, because we have a lot of flexibility on that. That isn't a strong position our clients have been holding.
Right. And our client also wants us to explore the possibility of FilmFlix acquiring our cable network. However, they haven't given us a specific position on that. However, we on our own have decided that that is probably in our client's best interest because of the uncertainty with our brand when it comes to that. So, but that's something we want them to bring up first, because if it's something that they want, we want to use that as leverage.
Yeah, and we have flexibility there. It isn't an end all be all. We don't have to, sell off the cable company if it's not a good deal for us. Additionally, we're in a strong position because, again, they have to sell themselves to us, and we want to play to that.
So that means we want to use a mix of a competitive and a collaborative approach. However, like we've said, we feel that we're generally in the stronger position here because we have two offers on the table. We could go either way. Our client has instructed us that we're not bound to accept this offer with them. They'd be willing to walk away if we don't get those specific things that they want.
Absolutely. But we want to keep in mind that we don't want to push too hard because our client is favoring the deal with FilmFlix, but it's got to be the right opportunity. And as far as roles, we don't necessarily want to have rigidly defined roles in this negotiation, but we've kind of discussed that I will take the lead on the opening of the meeting and kind of discussing the reverse termination fee.
Right. And I'll take the lead on some of those antitrust law issues that might come up. And then the potential discussion if FilmFlix wants to acquire our cable company. And I'll keep a list of our tentative agreements that we come to as throughout the negotiation.
Absolutely.
All right. Sounds good. We're ready to go.
Hi, good to see you again.
Yeah.
Thank you so much for taking the time to meet with us this evening.
Absolutely.
We think that this is going to be a really great deal, and we look forward to discussing it with you.
Yeah, we appreciate you taking the time.
So again, we just want to emphasize that this is our last meeting and we're looking forward to kind of seeing what resolution we come to. We're fairly confident that we will be able to work something out, but kind of in going into that, the first thing we'd like to discuss is the reverse termination fee.
Before
So
we get to that, I do want to know, what does your client think about our current offer?
I think that we have another very competitive offer that we are strongly considering.
Yeah,
And
course.
our client, they're considering your offer. However, there are quite a few things that we would like to discuss in order to make it more attractive to our board.
Were there any terms in the offer that were preferable to the competitor's offer? I just want to know how you guys are feeling about the current state.
Well, essentially, the way we look at it is, at this point, we've got the two competing offers in front of us. So we are kind of seeing this meeting as an opportunity for you to let us know if there's anything else you'd like to add or increase on your offer before we take it back to the board of directors.
yeah, so we know what all of the public offers are, and we definitely are willing to talk about the reverse termination fee. I know that that's important for you guys. Can you talk a little bit about what is appealing to Cardinal Universal's offer and compared to ours, just so that we have an understanding of where the priorities are, because we really want to make this work.
Yeah, absolutely. But I think just to put them on the same kind of playing field, Cardinal's offer just off the bat has a reverse termination fee. And our clients aren't even willing to discuss having an agreement with FilmFlix without this.
And the main reason we're concerned about that is, as everyone knows, there's some really big antitrust law issues with this because, our clients are very successful. They're the two biggest streaming companies in the industry. And so this would be probably classified as a horizontal merger because our companies are direct rivals. So that increases the likelihood that if there's an antitrust challenge, a court's going to invalidate this transaction.
Absolutely. And we also just need assurances that your company believes that this deal is going to go through, whether it's through financing, whether it's through, the antitrust and like federal regulations. So we'd like to get that out of the way first.
Absolutely, yeah. And we're open to that. And I do want to just make it known that FilmFlix is very serious about this offer. They're interested. And we are willing to work with you guys on anything that will make you feel more secure in the process.
The other important thing to note too is that FilmFlix as a company is not comparable to Cardinal Universal. So keeping that in mind, while their offer might have more of a cash value, FilmFlix is bringing a lot to the table as to what we can offer as a company for you guys.
And we acknowledge that. And we just need assurances though. And a reverse termination fee is something that is going to do that for us. And we acknowledge the benefits to a contract with FilmFlix, but we also acknowledge that there are benefits to a deal with Cardinal. So we just kind of want to lay that out there.
And one thing specific to our current circumstances is that, any transaction, there's always some risk. But with this transaction, since we do have a competing offer on the table, there's the additional lost opportunity cost that would, happen if this deal ultimately doesn't go through.
And for a reverse termination fee, do you have a figure that you find reasonable?
What does your client find reasonable?
Well, in an effort to show that this is something that we were thinking about and preparing for, we did do some research on it to try to find some comparable cases that were recent and wanted to show those to you. We understand that we want to give you time to look through these as well, but we've printed copies for you. Some examples of these mergers are Amazon with MGM, AT&T with Time Warner, and Federal Trade Commission wanted to stop a merger with Qualcomm. But all of these cases, which are again similar to ours, the courts have said that because there was no harm to customers that were shown, that the regulatory concerns were not a concern. And that's similar here as well, because it's distinct that this is a streaming service. There are still lots of different options for consumers to go to. It's not necessarily going to affect their price point. And for all of those reasons.
Well, yeah, one concern I'd have with that though is that if there really aren't many, potential antitrust concerns, was there a reason why the initial offer didn't include a reverse termination fee?
Our client didn't indicate that there was any reason one way or another.
Okay.
So, and we acknowledge, the value of case law. However, we just we really would like to get this number kind of out of the way. So if you have if it's based on the case law, great. If not, we just kind of want to get this number.
And
So
that number would give you guys comfort and security with this transaction.
So our thoughts going into this agreement is that it's your last opportunity to put your final foot forward. And so we believe it's your position to put forth a reverse termination fee.
Oh, absolutely. I just, I want to know what it would take for your client to feel that security. And I don't know them, so I can't speak to it.
I mean, we can start the conversation around 5 billion.
Absolutely not, no.
our client's not going to be willing to go up to 5 billion for sure.
Right.
Our public offer right now is the 38 billion as an outright offer for this acquisition. Reasonable termination fee is somewhere from 2 to 3%. Would that be acceptable for you guys?
So given the significant antitrust risks with this, as we both know, there's been significant media coverage on this thus far. We don't think that 2 to 3% is enough, and we understand that that's kind of a general idea, but there also is a lot of case law that suggests that a higher reverse termination fee is appropriate in cases that there's a more significant chance of having regulatory concerns.
Do you have examples of those cases?
Just while my colleagues looking through that, I mean, so you discussed like 2 to 3%. And as we had expressed to you, our main concern is the antitrust issue. So given recognizing that those are our concerns, would you be willing to move up to around like the 5% area in terms of your original 38?
We have some flexibility, but we also want to make sure that we're starting on the same price point. So the public offer of 38 billion is acceptable for you guys, I am gathering.
So not necessarily, we can discuss that later, but my question for you is, does your client believe that this acquisition or merger is going to go through as far as the regulatory concerns?
Absolutely. We've done our due diligence on this topic, and we wouldn't be here if we thought that it was improbable.
So if you believe that this is going to go through, what is the issue with giving a higher reverse termination fee?
We are willing to show the work that that our clients are willing to walk with you guys all the way through, distinct from Cardinal Universal, who is wanting to potentially walk away if negotiations last longer than 2 months. Our clients are willing to put in the work because we really believe in this, and we think that it's going to go through per the case precedent that I showed. Furthermore, I have a case here. It is in Delaware, so it's not binding, but I do want to note that this court says that about a 6% termination fee is a stretch, and stretches the definition of range and reasonableness.
So I just want to speak to you saying that Cardinal is willing to walk away after 2 months of stalling. And that might be the case, but we don't anticipate it taking that long. Our board meeting is in 10 days. And Cardinal has indicated to us that they would like to further speaking with us. So we plan to have this wrapped up relatively soon, and we don't anticipate it taking too much longer.
So if we're negotiating into a potentially higher than average termination fee, where is there flexibility in talking about exclusivity? Because if we're going higher in that amount and showing that commitment to you guys, our client is going to want the same commitment back.
So essentially, everything tonight would have to be a package deal, but that is something that would allow us to have more flexibility on the exclusivity. So, we just talked about 5 billion being too much. I mean, we can start kind of, having a discussion, with 5 in mind, we can come to some sort of resolution on that.
Definitely.
So any specific numbers kind of coming down from that?
So starting from our offer, the public offer of 38 billion, if we're going a bit higher than the 2 to 3% termination fee, about 2 billion is well over 5%.
So I know you brought up the 38 billion public offer, but that to us doesn't really have a lot of bearing on what the reverse termination fee would be, because there's only three scenarios in which that would be paid. If you breach the contract, if the regulatory authorities don't allow this to go through, and if you can't secure financing. So if, assuming that you believe that all three of those things would happen, then you shouldn't have a problem giving us a higher reverse termination fee.
We're talking about common practice here and what is reasonable for our clients and what is reasonable to the courts. So reasonable termination fees, and a majority of them are 2 to 3% based off of the offer as a whole. So the price point, which we're willing to talk about if you wanted to start there, so then we can talk about the reverse termination fee outside of that. We're really willing to discuss. The point of the reverse termination fee is, of course, that there is some risk, and we're able to acknowledge that risk and are willing again to fight for it and think that we have a very decent chance of it going through. But we're wanting the fee itself to be reasonable.
I just have a quick question. So assuming that we could come to an agreement on the reverse termination fee, and we set that now, would that be something you'd be willing to consider in terms of increasing the overall dollar amount of your offer?
Can you ask that question?
So for example, if we were to lock in, right about like 3 billion right now, and then we were also to potentially increase your overall dollar amount on the offer, if we kept it at 3 billion, is that something that you'd be willing to potentially increase your overall dollar amount because it wouldn't thereafter affect the reverse termination fee?
An increase in any kind of substantial way on that sticker price, depending on that reverse termination fee, I think wouldn't really make a lot of sense, considering that the end goal is to not have that fee be touched at all. It's really just an insurance. And so to take that into account when speaking to, potentially an additional $1 billion or $500 million, I don't think our client would be willing to do that.
So how do you feel about a ticking fee then?
What?
A ticking fee. So we can contract to a number as a reverse termination fee, and kind of to assure us that there aren't going to be significant regulatory barriers. If we would essentially set a date, and if it is taking longer than that date, the amount of the reverse termination fee would increase. So essentially, if we started it at 3 billion, we would set a date at some point in the future, just say 6 months. If our agreement, our merger doesn't go through, or it has some sort of halt, then it would be increased to say 5 billion.
Our client wants to keep the reverse termination fee corresponded to the price of the overall offer. This is common practice. We're willing to talk about that, the price of the offer to get the termination fee a little bit higher. But again, we're wanting it to be reasonable, which is a percentage amount to what the cost of the whole is. So if you guys are okay with that 38 billion offer, we can go from there.
Well, so like we said, for us, we really can't get further into the negotiations until we know that if something does happen, we're going to be secured. So what I've gathered from our conversation so far is I think I heard you say 2 billion would be potentially amenable. I'd propose 3 billion. It sounds like that would be, too high for your client. Is there somewhere between 2 and 3 that we're kind of starting to come to a middle on this?
Would you be open to 2.2?
We got to get closer to the 3 billion number.
Can we just split the difference on 2.5?
I think that would be reasonable for our client.
All right. But we're off to a great start then.
Absolutely.
Now, going off of that 2.5 amount, our client is again going to want on a contingency of that, some reassurance about MSP's commitment to this merger. Again, FilmFlix is bringing a lot to the table as far as what their business is. So we are hoping for that 10-day exclusivity leading up to the conversations with the board.
Realistically, it's not appropriate to discuss that at this time because we don't know the entirety of your final offer. So we can't cut off communications with other offerors, Cardinal and any other potential offerors without knowing what your final deal is going to be.
Which we will be giving you at the end of the meeting. And we know that your board is going to meet in 10 days to vote on this proposal. And we just want to have that security and knowing that it's not going to go back and forth and be drawn out potentially for months. Knowing that this vote is going to happen, knowing that the board is meeting to discuss this eventual offer, we also just want that security of knowing that it won't be interfered with.
Are there certain, so the way that we see it, we made public offers regarding price, brand integration. We're talking about the reverse termination fee now. So if we're able to solidify those by the end of this meeting, is exclusivity on the table?
It is definitely something we can consider at that point. Absolutely.
Yes, because when we're talking about all of these things, that's going to be really important for our client to keep in mind as well, to show that MSP is just as committed to this deal as FilmFlix is. And it's important to note as well that FilmFlix is making their offer on StreamCo only, and there is still room for negotiations in regards to the other avenues of your business with Cardinal Universal.
Yeah, absolutely. We understand that that's important to you, but we also need to ensure that we are putting forth the best possible deal for our clients before we can cut off any other communications. So I also don't want to assure you that we are going to come to an agreement on that by the end, but it's definitely something we would be willing to consider.
That's
And the
great.
main reason for that is because, we represent the board of directors. They have a fiduciary duty to the shareholders. So we just don't feel that it would be ethical to foreclose the possibility of considering what might be a better offer from a competitor until we know that we've received the best offer
And
from your
that's
client.
totally reasonable. I get it. And as long as we're able to discuss the other subject areas that I mentioned and we come to an agreement on those, we wanted to make sure that the exclusivity clause was on the table, because if it wasn't, then the rest of it was moot.
Excellent.
Okay.
Well, and I'd heard you mention that, so your client's potentially considering other aspects of our business.
No,
No?
no. Our FilmFlix is wanting to make an offer StreamCo only,
Okay.
which is distinct from Cardinal Universal, which is 60%. Their public offer at least was 60% controlling stake of MSP as a whole.
And with the cable companies, right?
Yeah.
So, okay. So your client's focused just on the streaming.
That's
Yes.
correct. And
Okay.
it would be a clean transaction. There wouldn't be any shared governance after the fact,
Mhm.
which is advantageous for MSP, considering that shared governing would introduce some friction in decision-making, slow things down, and essentially leave you with a partner who may be at odds with you. Whereas with our offer, it's complete. It's 100% for StreamCo. It'll give you a good cash infusion for the debts that your client is holding on to, as well as an opportunity to move forward in a more balanced way.
And just taking 100% acquisition of StreamCo would help with those regulatory concerns as well, which was we were keeping in mind.
I don't know if necessarily it would, though, because we are direct competitors, we're direct rivals in this business, and there are a lot of concerns with that for horizontal mergers. Courts tend to look at the fact if you're a direct rival or you're going to lessen competition. So we're still a little bit hesitant as to that. So do you have any?
In some of the cases that I passed on to you, which again, if we get to the exclusivity clause, and we can talk at a later date as to the details of those, but those cases say that that is mainly a concern for mass media and traditional media companies because there are less options. But for streaming services, when there are lots of options and it doesn't necessarily affect the price point for consumers, it does tend to be acceptable for courts. So that's another reason why we're not wanting to take over the other avenues of your business. We're only wanting to take over the streaming.
So with that in mind, how does your client feel? You said you mentioned that 38 billion. Is that a pretty firm number? Is there some room on that?
We have some flexibility here.
And does that flexibility take into account whether the breakdown is more so cash-based or stock-based?
So we are hoping, we want to stick to the 70%, 30% split as far as cash stocks goes. We have a little bit of flexibility there, but not much. There is some flexibility as far as the offer as a whole. It sounded like you guys were okay with the 38 billion.
Not necessarily. So speaking to your flexibility, can you give us a number on that?
We can go a whole other billion, up to 39 billion.
I mean, essentially for us, which is why I asked, is that, depending on how much you can go more so in terms of cash offer compared to stock, that's going to affect what we can accept as a top dollar. And it is important to note here that right now the current offer from Cardinal is $40 billion. And Timothy, like you had mentioned, that the cash, the 100% cash would be something that would help pay off our debt. Whereas, with the current offer from your client, it's only 70% cash at this point.
That's right. And with the cash that we're offering, it would help with reconciling some of those debts. And with the stock options, it will allow for more steady future going forward, considering the stature of our client.
Yeah, the partnership with us would help you guys not only in the short term, but in the long term as well. And while Cardinal Universal is offering the 40 billion cash, that is for the 60% controlling stake of MSP as a whole. We're offering a very comparable amount, just 2 billion less, for only the StreamCo portion of your business.
But we still get to maintain 40% of our company if we were to go with Cardinal.
As a minority shareholder.
Which opens the
Absolutely,
door
yes.
for friction between you guys. So this is much cleaner and a better option.
Well, can you give us a persuasive argument on this this stock aspect of your company? Because one of our concerns going into this is that it's essentially a problem that both of our clients are having, is that the streaming industry is plateauing in subscribers because it's so oversaturated. Consumers have expressed frustration with how many different streaming companies there are that they have to have. If they want to see their favorite shows, they have to have like multiple services. So do you have any like future projections in terms of how valuable your stock will be to us going forward?
Yeah, so what makes our stock distinct is that FilmFlix has not had to do a merger in order to find success. We started in 2007 as a DVD mail service company, and distinct from MSP and also Cardinal Universal, have been able to stand on our own. MSP stock went up 11% when FilmFlix's offer went public. Furthermore, FilmFlix is the most successful streaming service that there is known globally. All of these things make our stock incredibly valuable.
But it's also important to, I'm sorry. It's also important to point out that, when our stock went up, that was also around the same time that Cardinal was proposing their offer too. And, as we know, the market's always fluctuating anyway. So, I'm not sure how much of that we can attribute. We do recognize the value that your company can bring, but,
Yeah, and additionally, Kathryn, we acknowledge that FilmFlix has been able to stand on their own and has been successful, but that doesn't necessarily mean that it's going to be the trend forever. And also just taking into consideration that subscribers are getting frustrated with the fact that they have to subscribe to so many different platforms. We anticipate that there is a trend going back to cable, and that's what we still have. So we might still actually be a rival with you guys if this merger was to go through, just on a different level.
So, and as we said, we recognize your company's past success, but is there anything that it's been doing to try to address some of these concerns that consumers have had with the streaming industry?
FilmFlix has not had these same concerns. We've only known success, and we're not in a position where we are concerned about our stock. Having gone through a merger, we are confident that MSP stock rose after FilmFlix's offer was the one that was made public. And we feel that we're in a position to be able to adjust with the times, as FilmFlix always has.
And your company has been kind of opening up into some new avenues with like original content production too. Is that correct?
That is correct.
And which is one of the reasons why our company essentially would be able to bring so much value to yours, right? Because having those assets would allow you to, break through more into that original content production.
As my colleague has said, we've faced a lot of success in this industry, and we're in a position where that success will continue with or without StreamCo. And I think there's a great opportunity for growth, for partnership, and that would be really good for the consumers specifically. And to compare us with Cardinal, I feel like isn't really appropriate.
So if we were to advance our offer to $1 billion more, so now we're at the 39 billion, but making it a 75% cash, 25% stock. So we're increasing our amount, and we're increasing the amount of cash.
I could tell you we're at least moving in the right direction. So we're making some progress.
I think we're still going to have to move a bit more on that because just comparatively, Cardinal's offer is 40 billion in cash. Your first offer was only amounts to about 26.6 billion.
For Streamco only, again, not for
Absolutely.
controlling stake of the company as a whole, which is incredibly distinct. So that's why that amount is reasonable. It is just a little bit less for a lot less.
I don't know if we can agree at this point about the reasonability of the offer. I think we still are going to have to increase the amount of total cash and move a little bit on the stock as well.
I mean, do you think at this point, we could maybe come back to this and address some of the other issues? Because potentially if we can resolve some of the other topics, maybe there's a little bit more we can explore with regard to the top dollar amount. So like, for example, one thing that our client, is concerned about is, to my understanding, the current offers that you would want Streamco to be ceasing within 12 months, essentially. Is that correct?
That's correct.
Yes, right. Well, so one thing that we have to take into consideration is, the employees who've helped us build our company into what it is today. So we want to be making sure that we're also giving them enough time to adapt to this transition.
Absolutely.
Yeah.
So with regard to the 12 months, does your client have any, ideas about potentially extending that amount of time? Is that something that's really important to this deal to your client?
12 months is a good benchmark to begin at. I think it would give enough time for that transition, for that brand integration. If more time is needed, we could discuss a slight extension.
What were you guys hoping for?
Well, so Cardinal's offering 5 years right now. So, so just with that in mind, like we'd said, we were just kind of coming here to see like what possible ideas your client might have.
Yeah. With that extended partnership, we fear that there would be some confusion among the consumers. It would hurt monetization and would be ultimately against our best interests if it goes on for too long. We do recognize that there needs to be some kind of transition, and our client would be willing to go up to 15 months if that would be more workable for you.
We're looking a little more towards like 36 months. So around 3 years, kind of sort of splitting the difference between.
Again, because Filmflix's brand is not comparable to Cardinal Universal's, it's much more well-known. We don't want to split the difference between Cardinal Universal's deal and also our public offer as it stands right now. We do stand some flexibility as far as meeting in the middle between what my colleague just shared and what you said at 3 years. Where would you be at a year and a half?
Well, one point I just want to make is you keep emphasizing that Cardinal is not comparable to Filmflix, but for purposes of this meeting, they are. Our board members are comparing your offers and of course your companies as well, but a lot of that's going to speak to cash, what is going to happen to the company in the future, meaning integration and those types of things. So for our purposes, they are comparable.
As far as cash goes, Filmflix has been very generous with the cash that we are offering and the stock value that we hold for MSP's future benefit. Furthermore, we are willing to work with the reverse termination fee at a much higher than market amount. So we're really confident with our deal. That said, there is flexibility with this brand integration. And I think I had mentioned the year and a half. Where is that for you?
One of you mentioned earlier that you think there would be confusion amongst the consumers if we were to kind of prolong this. I think otherwise, especially if we're retaining our cable company, I think that it will, make it clear where the separation lies if we were to kind of figure that out along the way. So I think we would still have to stay a little bit more towards the 3-year mark.
Our client is not willing to go more than 2 years. That is the deal breaker.
If we can get to 2.5 years, I think we can come to an agreement.
Deal breaker on this one. this is a deal breaker for us. And that is a big leap from the public offer that we made at 12 months.
So I think that's something that we might have to keep in mind as we go back to, would you like to go back to price and then kind of
Yeah.
work from there?
Definitely.
Okay. Now, just out of curiosity, why is it that Streamco has no interest in the cable company?
Again, we were,
That film flick, sorry.
yeah, I got you. We were recognizing the regulatory concerns. We were just wanting to stick to the Streamco to help with that in advance.
Yeah. Filmflix already has the infrastructure. It already has the model
Mhm.
that's been successful for streaming, and they're not looking to expand into
And
cable.
Filmflix is not broken, so we are not wanting to fix it.
Well, so with that in mind, we left off at the 39 billion.
Yep.
Yeah. Taking into account that Cardinal is offering us 40 billion, is there any more room on that?
We're willing to match Cardinal's offer at 40 billion if we can get that 2 years brand integration.
So it would be the 2 years brand integration in return for up to 40 billion.
Correct, as the offer as a whole. Sticking to that 70-30 split.
Well, I thought we were at 75 cash, 25% stock when we were at the 39 billion.
We moved to the brand integration, so I wasn't sure that we were definitive on that.
Okay.
Moving up in the stock is moving in the right, or moving up in the cash is moving in the right direction for us. So I think we'd have to keep talking at least 75% cash.
Because then it comes back to what we had said before, essentially, is that, like Timothy had mentioned, that a lot of that cash would be going towards paying our debts. So that's why it's kind of hard to essentially agree to a deal that would be less than 40 billion in cash. I'm not saying that's the end all be all, but that's kind of the background against which we're working.
I'm just curious. Do you have a figure on the running debt for MSP?
No, we do not. But we aren't necessarily, the debt isn't so much of a pressing issue for us right now. We have 12 months to kind of figure out what we are going to do with that. So we're in no rush to kind of rush to deals and conclusions on that. And MSP isn't necessarily going to sell their company at all. We have the ability to keep going as we are. We have a lot of people working to figure out what the best option is for us. And that might be changing marketing, that might be expanding, that might be selling. So the debt for us isn't necessarily a pressing concern, but if we are going to make a deal in which we are selling our company, we need cash to kind of support that.
And just adding on to that, I think during this negotiation, there's been kind of a downplaying of the value of our cable network. I can tell you right now, if we don't go through with this deal, that's one thing that we're considering is investing more into the cable network, because there are some statistics in the market right now that the consumers who are frustrated with the amount of streaming services are looking at potential other, television services. So just taking that into consideration as well.
Absolutely.
Nice.
And our client can acknowledge that, while at the same time, our interest is in Streamco. So if we're talking 40 billion, which matches Cardinal Universal's offer, we would be looking at the 75-25 split for that, the cash and stock. That is 30 billion cash, which is just 10 billion short of what Cardinal Universal's offer is. Again, Cardinal Universal offering that for MSP controlling stake as a whole. This is just for Streamco.
Realistically, I think we'd have to go up to 50 billion.
We're able to work with you on a price, but we're not going to overpay for Streamco.
Well, as of right now, you've only went up 2 billion since your initial, and that's only matching what Cardinal has provided for us. And realistically, our client likes the idea of 100% cash. So given that this is the last meeting, and our last opportunity to make something happen, we're going to need to work on the numbers to even have it be comparable for them.
Filmflix has the opportunity to walk away. I know that MSP has the 12 months where you want to close your debt to income ratio. Filmflix does not have that pressure. So while we understand that Cardinal Universal is offering the 40 billion in cash as a whole, it is unreasonable to our client to go much more higher than that. The 40 billion that is matching their offer for StreamCo only, not controlling stake, is fair and reasonable.
But first, it's not cash. And second, our debt, again, is not necessarily so pressing for us right now. We are still getting offers with this debt in mind. And additionally, we have time. We're not necessarily so concerned about that. Of course, it's in our mind, but that's not where everything lies.
Have you had any conversations with Cardinal about a separate sale of just the cable networks? In the event that this deal were to go through, you could be a partner for them in that scenario as well.
We haven't had direct discussions about that yet. However, they have expressed interest in wanting to continue conversations of this negotiation. So of their current offer. So that could be potential, but we would be leaning more towards the entirety.
Yeah. For a situation like this, I think a deal with Filmflix for the terms that we've mentioned, and then a partnership with Cardinal, it would give your shareholders the most value for this transaction. And
we absolutely acknowledge Filmflix's, success in this industry, but we can't turn our backs to the trends. Subscribers for everyone has kind of plateaued right now. So we can't necessarily say that this trend is going to last forever. So that's not necessarily where we can kind of end.
50 billion is unrealistic, and we're going to have to go way lower, closer to what we're offering.
So, I mean, the 40, it's not out of the question, but the thing is that if we're going, like we said, essentially what it comes down to is that cash is certain. We would have it on the table today. It's something we can give to the shareholders. We don't necessarily know what's going to happen with the streaming industry. So if we want to stay at the 40 mark, we're going to have to come up more on how much of that is actually going to be cash. But if you have more flexibility in terms of that 40 mark, then, the breakdown with the stock is still something we can consider.
You had mentioned that you guys did not know how much debt MSP was in. So can I ask, where is the emphasis on the cash coming from?
Yeah.
Well, go ahead.
Oh, are you referring to like why it is that we would want more cash out of this?
It is our impression that liquidity was important because of the debt that MSP has. But if you're not sure what the debt is the amount of cash out of concern in comparison to Cardinal Universal. Again, because we are confident that Filmflix's stock will be more profitable in the long run.
Well, I mean, of course, a corporation is going to be confident in its own stock, right? So, but we have to take into consideration what the market is going to do. So,
I would put my bets on streaming rather than cable, personally.
And while our personal feelings are backed by the stock rising 11%, StreamCo is still the largest streaming service globally. We have a lot that is backing the value of Filmflix's stock.
And we absolutely value that. However, when we're bringing this forth to our board, they're going to look at a couple things, and it's not just going to be how well your company's doing. Money talks, realistically, and having a set amount of cash in front of them is going to do a lot, especially when they like the idea of still retaining some of our business. So if they're not going to retain any of their business, they need more cash to kind of bridge that gap.
Not knowing a realistic price point is where we're struggling a little bit right now. 50 is not realistic.
So then propose something to us that's more towards what you deem realistic.
About 40.5.
And what's the breakdown on that?
We can stick with the 75-25.
I mean, realistically, that's just not going to do it for us. We're going to have to move a little bit on that.
The highest that our client will go is the 41.5. They're willing to walk away if it's more than that. And we can stick it to the 75-25% split. that's the highest.
And we would also need exclusivity.
Well, so I appreciate that at this point, you've gone above what Cardinal has on the top dollar amount. However, if that's the top dollar amount, can we continue discussing what the breakdown of that amount would be?
Mhm.
So is it where 75, where is that kind of in the realm as to what you can do for us?
It's over 30 billion in cash. It's 31,125,000,000. And again, as to compare that to Cardinal Universal's public offer, that is as a whole more than what Cardinal Universal is offering. Even though that is less cash, it is just for Streamco.
Yes, however, it's risky. Stock is always risky. So this kind of agreement to begin with raises more regulatory concerns. So then if we're going back to our shareholders with this high stock offer, that they're going to see a lot of risk. And that's risk they're going to look at Cardinal's offer as a lot more safe, cash in front of them. And they aren't demanding exclusivity as well. Whereas your company is giving us less cash, less assurances, and that's just it's not going to be realistic for them.
We disagree with less assurances. We've gone up a more than reasonable amount for the reverse termination fee, and we're going up offering more than Cardinal Universal, while again, not having a controlling stake in MSP as a whole. We're being transparent because we want this deal to work, and this is a reasonable offer, more than reasonable. But again, FilmFlix is willing to walk away from this deal.
Right. We also with this setup with exclusivity, it's not the end of your conversation with Cardinal. We wait until your board of directors sits down, talks about the terms that we've come to today. They can either approve it, they can deny it. If they look at Cardinal and say, hey, we might have a better partner with Cardinal over FilmFlix, that's the board of directors' decision. I think that with the reverse termination fee that we've given, with the increase in the sticker price that we've given, we want you to know that we're serious about this.
Well, with regard to the exclusivity, is something that you'd be willing to consider?
Well, just something I wanted to say with the exclusivity, you said it's not going to be the end of our conversations with
It
Cardinal,
doesn't have to.
which we acknowledge. However, we want to go to our board with final offers, and Cardinal has expressed the interest in meeting again. So for us to completely close that off and not bring forth our best offers, that potentially could be a breach of our board of directors' fiduciary duties. So it's
a breach of fiduciary duty as far as where the best offer goes. It is in MSP's best interest for a clean cut as far as Streamco is concerned.
But
Cardinal Universal is offering 60% controlling stake for MSP.
But where is it coming from that it's in our best interest? Our board of directors has a ton of things to consider. And again, it's not just who is the most successful. It's not who's offering us the most money. It's a lot of different things. We're not at the point where
who is the most successful and who is offering the most as an overall offer are the most important things as far as these negotiations go.
But still they're offering us more cash. And additionally, our fiduciary duties are to look at what is in the best interest as a whole.
We've been very transparent as to what our final offers are because we want this deal to work. Anything higher than what we have offered is unreasonable, and FilmFlix is willing to walk away if it's higher than the highest offer that we said.
In terms of the 41.5 billion, can we go up more on the percentage of what is going to be cash? Because that's essentially what this means. To me, that's the main takeaway from this conversation tonight.
Our client hasn't indicated that they want to move from that percentage, no.
So, no, not even 80%?
Not at that figure. Maybe at one of the lower figures, we could have given more cash, but for the value that we're offering, we can't do that ratio.
I mean, I guess our final offer would be 46 billion and again 80% cash.
We'll have to take that to our client, but if we do, is the 2 years brand integration and the exclusivity?
Exclusivity we cannot do. I think the 2-year brand integration, I think we could do the 2 years.
We're gonna need the exclusivity if we go up.
That is not something we can consider at this time.
So it seems that we are agreeing on brand integration and the 2.5 billion reverse termination fee, but not price nor exclusivity. So we'll bring to our client what we've talked about today, and then we'll circle back for further conversations.
Absolutely.
Thank you.
It was a pleasure meeting with you again.
Thank you.
Thank you.
Thank you.
So essentially, we did secure some of the things that our client wanted.
Absolutely.
The $2.5 billion reverse termination fee, that was more than what they wanted actually, because our minimum was 1 billion. They asked us to go for 2. We got 2.5. So that was successful. 2 years brand integration. That's more than the 12 months they were originally offering. I thought it was good that we stuck to our guns in terms of how we were looking for more money. They kind of portrayed our company in a way that it wasn't as valuable as the money we were asking for. However, they came here for the second meeting with us. They did move on their original offer. So I think, we held our own in regard to that.
Absolutely. And, one thing they kept emphasizing is that Cardinal was not comparable to them, but I don't think they were looking at it in the sense of what our board of directors would be looking at. We don't just look at one thing. There's a lot of different things. And I think there's value in Cardinal's offer as well. And our board is more than willing to consider it, but because they couldn't move very much on the cash that they were giving us or the percentage, it doesn't look as favorable to FilmFlix.
Right. And then taking into account that our client was looking to get the most cash out of this, I didn't think it made much sense to essentially agree to less cash when we had another offer with more cash that still opened up the possibility of retaining our cable networks and having a continued role in managing our company.
Yes, and additionally, I think it was good that we emphasized a lot of the riskiness, not only with the deal as a whole, but also the stock. You never know how trends are going to go. And although our board of directors finds stock, attractive, they need more cash in order to kind of balance out the riskiness.
Yeah, and I think we countered their arguments very well. They were trying to really sell us on how important streaming was, but of course, the lawyers for the biggest streaming company are going to place their money on streaming. So I think we really emphasized that it's really about what the market's going to do. We need certainty for our shareholders, and at the end of the day, we're still an extremely successful company. Our client didn't instruct us that this had to be that we were required to close this deal today. We were supposed to get the best possible offer for them. And I think we put as much into it as we could.
Yeah. And I also think that both sides came into this not really wanting to give numbers, which, made it a bit difficult. But I think we eventually kind of came to some sort of agreement, begrudgingly sometimes, but I think it ended up, we got them to move a bit. Our clients they were overall happy with the evaluation, but again, like cash is very important to them.
Yeah, overall, I think, it might have been possible if we, had another meeting that we could have eventually gotten somewhere with that. We were starting to get to move in the right direction towards that at the end. So,
but I think the big thing is they really wanted exclusivity, which just didn't make sense for us, especially to talk about it as early in the negotiation as they wanted to, because we can't agree to be exclusive without knowing, the entirety of their offer.
right.
And I think that was, strategic on their end, but I'm glad that we didn't come to an agreement on that because it's not beneficial for our client in any way.
And as you'd mentioned, I think we did a really good job in terms of they kept asking us what we were looking for. But like we had said at the beginning, our whole mindset going into this this was their last chance to persuade us. And, unfortunately, when it came to the dollar amount, they weren't able to do that.
Absolutely.
move this. Good evening again. So my partner and I were talking about what we thought went well, where our strengths were, and what we would hope to bring to the table for any further negotiations with MSP. Points that we thought went well are that we were proud of the prep work that we made, especially in regards to the math and the numbers. So we were able to adjust what our offer was based off of the numbers that MSP was giving. They were less flexible than we were expecting for some of the talking points. So we were also proud that we didn't feel the need to end the negotiation in this meeting, but was able to acknowledge we came to an agreement on the termination fee, which was lower than what our client max limit was, and that there was still room for negotiation for the price, the brand integration, and exclusivity.
Yeah, we also did well with all of our other red lines. We didn't go over any of the hard limits that we were given. Our work between us, I think, was very good. It was very conversational, as well as with the other clients' representation. The conversation that we had was productive. I think it could have gotten a little bit more contentious in certain places, but overall it was fairly positive and productive.
Yeah, when they were giving the price of 50 billion and just being able to look at our chart and knowing that that was unrealistic and seeing what that their main concern was cash, but not knowing where their debt was, we were trying to pick their brains a little bit as to where that was coming from. I thought that we also did a decent job at asking questions to try to understand where their main concerns were. And in further negotiations, we most certainly would want to emphasize the exclusivity. That was really important to our client, along with the price being a realistic amount. That's all it. Thank you.
Thank you to our teams. You both did an incredible job tonight. At this time, the judges will convene in the judges' room for deliberations. Please rise. You may be seated. While the judges are deliberating, I would like to take the opportunity to say thank you to some people without whom this competition would have never been a success that it was this year. First and foremost, I would like to thank Hallie Dennison. Hallie, thank you so much for all your support and help throughout this competition, from helping me transition into my new role at the end of last semester to scheduling judges and 1L volunteers. Hallie has put an immense amount of behind-the-scenes work into this competition, without which none of this would be possible. Thank you for all the laughs we shared this past semester while we sat at the check-in table late into the evening. I really could not have asked for a better partner. Next, I would like to thank Josh Hacker, our Moot Court Board Executive Director, who has always been and continues to be an incredible source of support. He has been a great leader for our program and is always helping make sure every part of the organization runs smoothly. Thank you, Josh. I would also like to thank the members of the Moot Court Board for all the help, camaraderie, and positive energy. Every time I see each and every one of you, my day truly gets brighter. Additionally, I would like to thank all the attorneys who volunteered their time to come judge the competition, and all of our first-year students who volunteered as timekeepers. All of their names are listed on the back of tonight's program. Moreover, I would like to thank Julie Pamkowski, John Collins, our moot court faculty advisor, Professor Joe Hart, for making tonight possible. Lastly, I would like to give a tremendous thank you to the negotiation competition advisor, Professor Dan Bollana. Thank you for all your support throughout the competition, your kind words of encouragement, and your invaluable feedback and edits to each and every problem. Thank you, everyone. Now, Megan Dooley and Jack Rainey, who are our winners from last year's negotiation competition, will come up to announce the certificates for our quarterfinalists and semifinalists.
I go one by one. Like you say, Jasmine.
Okay. So first for the quarterfinalists, we have Jasmine Jordan Phipps.
And Max Majors.
Next, we have Carolyn Guaman.
And Nicholas Bifano. Oh.
Next, for the semifinalists, we have Favor Igabor.
And Raina Lee. And then finally, for the last semifinalist group, we have Michael Bono.
And Estefan Alba.
And now we wait until the judges finish deliberating so you guys can take a moment to use the bathroom, chat, rest up. Thank you.
I'm just gonna put it in.
That'd be awesome. Thank you so much. Now it's zeros. So I'm kind of got this off.
Hello, everybody. Testing, testing, 1, 2, 3. Sorry to interrupt the conversations. The judges are actually done deliberating, so they will be back momentarily. If the competitors want to sit, take their seats, and then, yeah, and everybody rise for the judges. Thank you. Yeah, I know, you're fine. I'll leave it to you.
Oh, you can all be seated. Yeah. All right, so I'll kick us off for feedback, and I have some brief comments for the competitors before I move into more substantive feedback. First of all, congratulations. Deep breath. It's it. You're done. You did the competition. I hope you're feeling a little bit of relief from this right now. I'm very proud of you guys. I hope you guys are as proud of you as I am of you. The moot court competitions are where you build the skills you're going to need for practice. And with those skills, you're going to change your lives and the lives of your clients, the lives of many other people as well. So, like I said, I'm very proud of you as an alum. I was very, very impressed overall. So my feedback, take it with the perhaps chaser that you all did very, very well. To kick us off, I'll start MacKenzie and Victor. I thought you guys started out very strong. You framed the whole negotiation as and I believe, Victor, you said it, this is an opportunity for you. That was a great way to kick off the conversation, a great way to start off the negotiation from a very, very strong point. And you used that very effectively kind of throughout the negotiation. At the end, you mentioned that you got them to move a little bit. You got them to move by $3.5 billion. That's not a little bit, that's a lot. And in fact, you browbeat them into their bottom lines all the way to the end. That's very strong. And then there was a point where I feel like maybe it was overconfidence, or you realized you got them to move by 3.5 billion. So, hey, what's another 8.5 billion? The jump from the 40 billion number to the $50 billion number at the end of it, that was dangerous. And I'd say you were very lucky that the other team didn't do what their client instructed them to do, which was to walk away. You could have tanked the whole deal right then and there because you felt that confidence of, well, maybe I can push you further. There's only so much you can push in a negotiation. Yes, that's a little bit of an art more than a science. Yes, there was these huge jumps. $1 billion is a number. I wish I had $1 billion. That would be phenomenal. But it's almost an unreal number. So I know that felt like you were moving by one each time. You were moving by 1 times $1 billion, right? You got to keep the perspective. You can't push so hard that you can tank the deal, right? And that number was given right after there was discussion about the debt that you guys were in. Hey, we're struggling for money. Please give us money. Anyway, 50 billion is kind of where we want to be. Those are two different standpoints from two different clients, not the same client, right? Keep that in mind. Keep your perspective in mind. Don't push too hard, and you'll find the bottom lines as you did. Okay. So phenomenal job finding the bottom lines. I'll move on. Kathryn, Timothy, I feel like you began the negotiation a little bit with an inquisitive attitude after being put in the position of, hey, we're here for your guys' benefit. This is your opportunity to make us happy. You're like, well, what is so appealing about the other offer? I feel like that's a good question to ask. Okay, if you really think you're in such a good position, tell me about the good position that you're in. And that worked very, very well because they didn't really have a great answer for that, right? You identified that. And then what was very interesting to me is that you started moving by billions of dollars without getting a whole lot back in return. And I felt like maybe it was that perception of, oh, they're in such a great place that they could also walk away. I think you guys were in the position to walk away. And I think it would have been effective at the moment where MacKenzie said $50 billion for you guys to stop. And okay, we're done, right? Because your client told you to do that. The client said, hey, listen, there's a bottom line here. If we can't get it, we're done, right? The deal isn't really something, and this goes for both teams, this deal isn't really something that you can take back to your client at the 11th hour. You're 10 days out from the board meeting. You guys are going to be making a decision presumptively relatively soon. So I feel like that may be a little bit of a nitpicky for me, but that wasn't necessarily realistic. You guys also moved tremendously. I think I mentioned that already, but you got to your bottom lines. I am glad that you mentioned that it was your bottom line and said, listen, this is as far as we go, to make that very, very clear to them. But again, I've watched big negotiations falter over much less. I think you guys were in a strong position to say, you know what, we're out. I get that it's a competition. The competition does make you feel like, oh, we got to reach a decision. That's not what you got to do. You guys don't have to reach a deal. That, again, this is universal. Negotiations, you don't have to reach a deal. You have to protect your client's interests, number one. But again, just to kind of go back to my overall feedback, very impressive. I'm very proud of this, and you guys should be too. So thank you. I'll pass it down.
Yeah, maybe I'll take this one. Holding up the big mic. So my opening statement will probably be the kind of thing that you hear from a professor when they give an exam. It was kind of fun to watch. Right? From my perspective, I really enjoyed seeing the back and forth and the interactions, seeing how the teams were interacting, being able to see the setup where you come out and talk about how things are, you hope they're going to go, seeing how you implement that, hearing afterwards the reflection on how you did. It showed me you're all extremely thoughtful, all really, really smart, all really, really engaged. So I really enjoyed it. So thanks for that. Again, and I get that it's very different for you. I've been not in that seat, but in front of this seat in a very similar position in this room. So I know how that goes. I was a little surprised. It wasn't really in the problem, but I was curious whether anybody was going to bring in any sort of like merger dynamics, cultural and public perception and optics and politics, right? Because you're talking about mergers and you have your cases in the past that whether this will get by merger. I don't think any of those rules apply anymore. I think it depends how you play the current political game, whether or not DOJ is going to get involved. And if you play the current political game at the federal level, does that mean the states are going to step in instead? So I think that there was probably a little bit of a discussion to be had there that wasn't explicitly raised in the problem, but was raised by it. That said, it was probably smarter to avoid that because you don't necessarily know where the other side stands in relation to all of the political divisiveness that's out there right now without it being in the problem. So I'm going to go into comments for the Film Flicks team, for Timothy and Kathryn. Really good interaction on the team, good support for each other. I thought that you were playing back and forth. I didn't hear people stepping on each other or contradicting each other in any way. I saw right from the start, prior to the start, you said, we kind of want them to set the agenda. I always think that's a little strange. Like, I guess maybe it's just me. I want to set the agenda. I mean, that's a law professor thing. Like, I get to decide what we're going to talk about and when. And I can see the benefit to it. So when you said it, I'm like, well, let's see how that goes. And I saw you trying, like there was a really hard focus on the reverse termination fee at the beginning. You kept trying to get it off and they kept going back to it. Well, you want to talk about that, but that's really about the reverse termination fee. And you were like, okay, well, what about this other thing? Do you know that's actually about the reverse termination fee? So you could have fought back more there, but I think you did well sort of going like, well, it seems like they really want to talk about the reverse termination fee. So let's see what we can do about that. I would have said at some point, if I was you guys, okay, I don't want to hear the word cardinal again. I don't care. If you like them so much, go talk to them. We're not competing with them. We're making you an offer. So that to me throughout, that sort of sprinkling both your own, because you would say, well, Cardinal is willing to do this, but ours is different. Here's my thing. I've got my own thing. I thought it was really good. One thing that I will mention as I transition into talking to Victor and MacKenzie and as the MSP team is I was acutely aware of posture, tone of voice, and other things. And tone of voice I thought was really good. I think it stayed throughout. I probably would have had a little bit more frustration at different points from both sides. You guys were always attentive up at the table. Timothy started back. Thing was in his lap, kind of leaning on the edge of the table. And you joined him as it went on. So you started up and then you went back. I don't think that's necessarily bad. But here's my point about this. And I say this point to people who do moot court as well. You should always be aware of your body posture when you're in a negotiation, when you're in a moot court. My rule for students who are doing moot court, you should never look down and see your hands moving. You should never look down and go, I wonder when I started leaning back. You need to keep that awareness because it sends a message whether you want it to or not, that you're disengaging, you're a little ambivalent maybe, you're not really sure, you're like going to put some distance. And you think like, it doesn't mean that I was just tired and I wanted to lean back. Not what it means. So be aware of that throughout. Again, I don't think that was negative in any way, but I did notice the change. And I noticed this change right from the beginning of Timothy, just sort of like, here we are, we've got some money. And that's sort of how that came across to me. So for MSP, you guys had really good, I don't know, can I use the word vibes when you came in and did your opening thing? So whatever connotation you're taking from that, don't. I just mean you melded well together. I probably shouldn't have used it as a team. And so the opening thing where you sort of talk to each other and prepare for each other was good. It seemed almost like the points were a little rehearsed. And then I noticed at the end, the conversation was the same and you couldn't have rehearsed that because you didn't go through the competition yet. So that's the interaction. I thought it was good. You played off at each other. I was surprised at the strong focus on the RFT at the beginning. I didn't pull that necessarily from the stuff we had so much that would be such a big deal. You really did a good job, as Ray said, framing the whole thing. Like, here's our negotiation. I felt like sometimes there was too much sticking there. Like, this is what we're going to talk about now. Oh, you want to talk about that? We don't want to talk about that, even though all the parts related. So I would be a little bit more flexible maybe about doing that while keeping your points, right, to go back to if you need to after. So again, like I said, it was really good. I mean, this is like a room full of people and you're negotiating. So I'm really proud of you guys. You did really well. Chief.
Thank you. And to echo your last thoughts, you came in nervous, but you're nervous because you care. And from my position, I was nervous because I did not know how this was going to go. Was there going to be a resolution? Was this going to be super contentious? Like, what was going to happen? Would it get really heated? Had no idea what to anticipate. So I'm grateful to have been here, been invited to judge this competition. And I do hope you're proud of yourself. You're nervous again because you care. You put a lot of effort into this And it showed for sure. I'm on the bench in a small city court, so I see attorneys negotiate every day. I see them negotiate so they can come to a resolution or settle a case. Different terms, of course. No billion-dollar deals here. We're talking small claims. However, still negotiations. And I saw something here that I don't get to see every day. I saw a level of professionalism that I hope never leaves you. I saw you all prepared. That was from the very beginning. I saw that. I also recognized the teamwork, how you played off of one another. And so my overall impression of you was that you were prepared, professional, and you had a lot of teamwork. And so my other first impression, the pre-negotiation analysis for MSP, you dove right in. I appreciated the casual yet professional tone that you had, but I also felt like I had to catch up with you, where it was happening so quickly that I had to get up to speed with what you were discussing. So while I enjoyed the casual professional tone, I had to catch up. And so that's something I want you to be mindful of going forward, okay? Or in the future, right? Because this is the end. But I like to think of everyone as that had a theme this evening. Everyone had a theme for me. And so I'm going to address you individually in the theme that I had for you as you were negotiating this evening. So, MacKenzie, I know in family court we discussed the best interest of the child. Well, MSP was your child today. And so you really advocated for MSP and that you would not leave any stone unturned. You came back for conversations that I thought we were done with, but you came back and you made sure to address them in the best interest of your client. And so, just reading my notes here, you came back for a fight and you did not back down. That was evident that you worked for the best interest of your client, the best deal for your client. So that was your theme in my mind, the best deal for your client. And you wanted assurance for your client because that's what you do, right? When you want their best interest, you want assurances. And so that was evident from the beginning that you wanted the best for your client. And that was my theme in my mind for you, MacKenzie. And Victor, I called you the calm conferencer. You had this calm power about you, but you were also the numbers guy. You kept bringing us back to the numbers. You were the first one no one wanted to put out a number in the beginning. No one wanted to discuss the numbers. And then bam, you said 5 billion. Or was it 5 million, 5 billion? You just said it right there. And I was surprised. You were the first one to ever mention a number, but then you also were the first to help us settle, to come to the resolution regarding, I believe, the reverse termination fee, right? You got us to 2.5 billion. You said, well, let's just come to split the difference here. And you got us there. So you were successful in that. And you did so calmly. You were all about the settlement. And so I saw that as a theme for you throughout. You were our calm conferencer. That's what I have in my notes. And you were about the settlements. You wanted resolution. And that was clear for you. You wanted resolution. Okay. But overall, great job, you both.
Thank you.
All right, moving on to film flicks. So my first impression of you for the pre-negotiation analysis, because I teach lawyering, I love organization, I love structure, I love a good roadmap. And I was you got me at that. That was a roadmap for me and I loved it. So you got me there, where it was clear what was important to you. You had the 4 issues outlined for us. And I was able to easily follow what your goals were, what you needed, what you wanted to discuss, and in what order. And so that was really helpful for me in understanding the background, providing us with content, even though we had the content, but it was nice to hear you outline that for everyone. So that was my first impression with the pre-negotiation analysis. So I'll start off with you, Timothy. Timothy, I have your theme for me, the straight shooter. That was my theme for you. You were the one who took control of the conversation from the beginning. I know MacKenzie tried to steer us in one direction, and your response was, well, what do you think about the offer? And you posed the question right away. She had one direction she wanted to go in, and you said something different. And so you took control of the conversation from the beginning, and you had this command about you and your voice. I know we discussed posture and your demeanor. You took control of a lot of the conversation, but in a very subtle way. But you were straight about it. And so I know there was a conversation around the number of months where we went from 12 months and you budged a little bit to 15 months. Not much, but you were concrete in your answer there. You said 15 months. That's what we'll do. That's as much as we'll push it. Some of I hear catchphrases from you, not catchphrases. Well, you were very straightforward in your responses. I wrote some of them. Absolutely not. There was something said on the other side, and your response was absolutely not. And that was that. You didn't have to say anything again about the topic. It was, no, that's not what we're doing here. That's not what our client is agreeing to. Another phrase, we will not overpay. We just won't. And not possible. And we won't move. And that was you. That was your theme. And it's effective. It was very effective. And so you were the straight shooter. And last but not least, Kathryn, you also had a calm confidence about you. And I think your confidence came from, I had the 3 R's for you: research, rationale, and reasonableness. And those words kept coming up for you. You wanted to, the only way you would justify the numbers was through the research. You would keep going back to, well, what's reasonable here? What has precedent shown us? Even if it didn't show us too much, you stuck to that. That's where your confidence came from, was what was rational, what was reasonable, what the research says. And so the only reason you were willing to become flexible was because you drew from the cleaner, better option. Again, going back to reasonableness, going back to what was rational. And so the precedence was big for you because what's precedence? What's the value of precedence if the facts don't align with what you're presenting? And so you kept going back to the facts of this negotiation and why it was important and why the precedence should have been used, even if it didn't really say so. You kept returning to that, and it was convincing for me, at least. So, and that's what I had for you. You get research, rationale, and reasonableness. Okay, but overall, great job, everyone. I really enjoyed this competition. So as the chief, because I've been placed in the center, I've been tasked with announcing the winner of the competition. Okay. I'll just go right ahead, no drum roll. So the winner of the 2026 Donna Jo Morse negotiations competition is FilmFlix. Congratulations.
I would like to congratulate our winners, Kathryn Benedetti and Timothy Nolan. Both Barbary and Brown Weinrob Advisors LLC are actually sponsoring tonight's prizes for the winners, so you will be receiving information soon. Thank you, both Barbary and Brown Weinrob. I also would like to thank our judges this evening. Thank you for giving up your valuable time, and we have a small token of appreciation for you, which I will give to you at the end. And finally, thank you for everyone here who's in the audience. Thank you for coming tonight. I hope you can join us for our reception in the East Foyer downstairs. Have a great night.